In premises liability cases, there is often a defense known as open and obvious. Let me just explain. Premises liability cases are exactly what you would expect. Cases against landowners, premises owners, or management companies. And often, but not always, they're slip and fall down cases. A premises liability case could be where somebody gets injured, for example, in a pool, swimming in a backyard. Now it was the fact situation of a case decided by the Supreme Judicial Court of Massachusetts in 2000, known as O'Sullivan v. Shaw. And in that case, the Supreme Judicial Court said and upheld this notion of an open and obvious danger as precluding or stopping a plaintiff from bringing a successful suit. It was not a surprise that the court decided as it did, because in the O'Sullivan case, the plaintiff unfortunately dove into a shallow end of the pool and suffered serious injuries. The plaintiff argued there should have been a warning given, and the court rejected that, saying you don't have to give a warning in an open and obvious situation. I even recall the Boston Globe editorializing in favor of that decision. And it would be hard to argue with the wisdom of that. But not all cases are the same. And in fact, in a swimming pool accident, where actually a client, not of mine, fell off a deck because there was insufficient lighting and there was no handrail around the pool, that client was not stopped, was not precluded from bringing suit by the open and obvious doctrine. In fact, the judge who said the case can go forward cited the fact that O'Sullivan was a failure to warn, and yet that case, the second case I'm talking about, was a case where there was insufficient lighting and an absence of guardrails. And the court, that is the judge, who was Ralph Gantz, now the Chief Justice of the Supreme Judicial Court, stated that you shouldn't allow someone in control of property to have a knowingly dangerous condition and then say it was open and obvious. For example, on a porch, you couldn't have a situation where there were no guardrails and then say, well, it was open and obvious, the person should have known and should not be allowed to proceed with a lawsuit. That is not the case. There still has to be adherence to a duty of reasonable care. And of course, how that reasonable care is determined is up to a jury or is up to the arguments of attorneys and insurance companies. But I do want to speak again to those who find themselves victims of the argument of open and obvious. It is not a defense in many cases. It is something having to do with an argument about the failure to warn. And I submit that on fact situations as clear as somebody diving into a shallow end of a pool, you can't expect the landowner to give a warning because that is rather obvious and commonsensical. But many times when this argument is raised in the fall down, slip and fall premises liability context, the defendant, the insurance company, is using that doctrine in an unfair way and in too broad a way. Thank you.